In a silent courtroom, tension breaks. Rebecca collapses as the judge delivers a life sentence. The grandmother's words cut through the air.
To destroy my whole family.
And then, one chilling question echoes across the room. Was Emmanuel finally found? Or is the truth still buried somewhere no one has dared to look? The courtroom doors open. Jake Haro enters beside his public defender. He is escorted by deputies and seated at the defense table. The attorney places documents before him. Neither speaks. The defendant remains still, his hands resting on the table. The attorneys for the prosecution, William Robinson and Brandon Smith, are also present. The audience in the gallery is silent. All seats are occupied. The court staff review microphones and confirm the recording devices. The bailiff announces the beginning of proceedings. Everyone stands as the judge enters. The command is clear and formal.
And before we go forward with the sentencing in the Jake Haro matter, again announcing to the public there are no use of cell phones, no recording except for the pool camera. There will be no comments about the case while the court is in session, no outbursts, and please follow instructions given by our RSO.
The judge reminds those in attendance that the use of cell phones or any form of private recording is prohibited. Only the pool camera is permitted. The courtroom is ordered to remain silent, without outbursts or commentary. Deputies are instructed to remove anyone who violates the rule.
And before we go forward with the sentencing in the Jake Haro matter, again announcing to the public there are no use of cell phones, no recording except for the pool camera. There will be no comments about the case while the court is in session, no outbursts, and please follow instructions given by our RSO.
When the judge takes his seat, he identifies the matter on the record, People versus Jake Haro. He confirms that the defendant and counsel are present. The prosecution confirms readiness. The defense does the same. Both sides acknowledge the court has reviewed all sentencing memoranda and the probation report. The judge asks if there are any preliminary statements. The defense attorney briefly objects to the imposition of fines and fees, explaining that the defendant is indigent and had been receiving disability benefits before his arrest. The attorney requests that any restitution fine be set at the statutory minimum of $300.
I believe that the court is going to sentence him to a lengthy sentence. And prior to his arrest, he was unable to work and was receiving disability. So we would object to the court imposing any court fees and fines. If the court is going to assess a restitution fine, it is based for the defense request that based on the indigency that the court set no higher than $300, which is
the prosecution responds. Mr. Smith states that the people oppose leniency of any kind. He reminds the court that the case began with a fabricated claim of kidnapping, which caused public alarm and required extensive investigation. He emphasizes that the defendant's deception wasted resources and deepened the harm to the victim's family. The judge notes the arguments. He then inquires whether there are any victim impact statements. The prosecution indicates none will be presented. A brief pause follows. Then, Mr. Smith informs the court that the victim's grandmother has requested to speak. The judge grants permission. Deputies assist her to the podium. She identifies herself as Mary, maternal grandmother of the victim, Emmanuel Haro. She spells her name for the record. The judge confirms that she may proceed. Mary begins her statement by asking that the defendant look at her. She says she told him before his arrest that she would attend his sentencing. Her voice is steady. She states that the defendant destroyed her family and caused irreversible damage to her children and grandchildren. She mentions that she never had the opportunity to meet Emmanuel. She recounts contacting social services in the past to express concern about her daughter's safety and the defendant's behavior. She says she was told everything was fine. She describes how those reassurances prevented her from intervening sooner. She adds that she fears her daughter was changed and isolated by the defendant. She continues the defendant harmed not only his children but also extended members of the family. She says he deprived everyone of peace, and that her grandchildren suffer because of him. She mentions public speculation and online accusations directed toward her family, saying, "Grandma doesn't know anything. Mary expresses anger toward the judicial and child protection systems, asserting that the defendant had been given multiple chances. She references prior incidents and says,
And I think the judge that let him go should be here sitting with him. And so is social service.
Her statement concludes with a direct plea.
And I stand here with you asking you to give him the maximum. Because I don't want him to give him another.
The judge thanks her and acknowledges the pain expressed. He states for the record,
I do want to lead with, I'm sorry for your loss. I'm sorry for all the hurt that you and your...
The courtroom remains silent. The proceedings continue. The judge confirms there are no further impact statements. Both sides submit their motions. The court prepares to pronounce the sentence. Before doing so, the judge outlines the legal reasoning. He notes that the defendant was on probation at the time of the new charges, including a prior felony involving another child. Because of this, the court finds the defendant ineligible for probation under Penal Code Section 12003. He explains that both determinate and indeterminate terms apply. For the charge of murder in the second degree, the judge imposes the term of 15 years to life. For the charge of Jake Haro, the court imposes 25 years to life. The judge finds these counts arise from the same act, and therefore applies Penal Code Section 654 to stay one term, selecting the greater sentence. Additional charges from prior cases, filing a false report, are addressed consecutively. The total determinate term equals 6 years and 8 months, plus an additional 180 days in custody, to run consecutive to the indeterminate term of 25 years to life. The judge explicitly denies probation and any request for concurrent sentencing. He states that aggravating factors outweigh any mitigating ones, and that the early guilty plea does not justify a reduced term. The judge says, while the defendant pled guilty at an early stage, this does not outweigh the seriousness of the offenses. He adds that the defendant's prior conduct, including crimes against his own children, while on probation, justifies the maximum penalty. The final aggregate sentence is read aloud. 6 years and 8 months plus 25 years to life, and 180 days to be served in state prison. The court then addresses fines and restitution. The restitution fine is set at $10,000, with an equivalent parole revocation fine stayed pending completion of sentence. Standard court operation and facility fees are imposed and stayed. Victim restitution will be determined later. The defendant is advised of his rights to appeal within 60 days. The judge also states that if future legislation grants additional discretion for lower sentences, the court would decline to apply it, finding the current judgment appropriate and proportional. After pronouncing, the judge directs the deputies to take custody. The defendant is ordered to be transported immediately to the Department of Corrections. During this process, Rebecca, the victim's mother, and the defendant's spouse, is present in the courtroom. She remains seated behind the defense table. As the sentence is read, she lowers her head and does not speak. Observers note visible distress. Deputies monitor the area as proceedings conclude. When the gavel falls, the judge says, "Court is adjourned." The audience remains quiet. The attorneys collect their materials. The defendant is escorted out through the side door under guard. Mary stays in her seat for several seconds before standing. She does not address the court again. Her statement remains the only family testimony recorded that day. Outside, reporters prepare to summarize the outcome for evening broadcasts. The sentencing is now official. Jake Haro, 6 years, 8 months, and 25 years to life. Within the official transcript, no direct mention confirms the discovery of Emmanuel. However, during her address, Mary referenced bury a grandson earlier that year, a statement later interpreted by some members of the public as possible confirmation. The court record does not verify that claim. As the session ends and deputies clear the gallery, the lingering question remains unspoken yet felt by everyone who attended. Was Emmanuel found? When the prosecutor informs the court that the victim's grandmother wishes to address the bench, the judge grants permission. Deputies guide Mary to the witness podium. She identifies herself for the record, Mary Ushas, maternal grandmother of Emmanuel Haro. The judge tells her to speak clearly so that the reporter can record every word. He assures her that there is no time limit. Mary nods once. Then she begins.
I wanted Jake to face me, to look at me.
She directs her request to the defendant. The judge allows it. Jake Haro lifts his head for the first time in several minutes. Their eyes meet. The tension is immediate and visible to everyone present. Mary starts slowly, but the words come stronger as she continues.
Because I told him that I would be here for his sentence. Because he didn't give me the opportunity to meet my grandson. He destroyed my whole family. He branded his children for life. He damaged her children, all his children.
Her voice breaks, then steadies again. She says her daughter was never the same after she began living with the defendant. She explains that the relationship isolated her daughter from the rest of the family. She recounts that she only re-established contact when she suffered a medical emergency, a stroke that brought her daughter back to visit. That was when she first met one surviving grandchild. She never met Emmanuel. Mary tells the court she had tried to raise concerns long before tragedy struck. She says she called social services when her daughter moved in with the defendant. She repeats what the agency told her.
Oh no, she's fine. The house is beautiful. They have food in the fridge. That's it.
She adds that she accepted that assurance at the time, but now believes it was a serious mistake. Her tone sharpens. She accuses the child protection system of ignoring warnings, of performing only surface-level checks, of giving the defendant repeated chances. She stresses that those decisions had consequences beyond her family, consequences that reached an entire community now grieving a child.
Oh no, she's fine. The house is beautiful. They have food in the fridge. That's it.
She says, pausing on each word. The statement moves from grief to indictment. She addresses the bench, then turns slightly toward the prosecution. She tells them that the family was blamed online. She quotes the comments directed at her. Grandma knows. Grandma's in on it. She says that accusation was false and cruel.
If I had known what was going on, I would have take my daughter out of there forcefully, or I would have called the police. My sons would have come and got her.
At this point, many in the gallery are visibly emotional. Reporters stop writing. A deputy shifts his weight, but remains silent. Mary presses forward. He didn't give anyone a second chance. He had his chance: probation, community work, and he wasted it. CPS said everything was fine. Well, look where we are. She repeats that the checks performed by social services measured only appearances: food, furniture, cleanliness, not safety. She argues that those superficial standards failed to protect the most vulnerable child in the home. That doesn't cut it, she says firmly. That's not fair to the children. Her words resonate through the room. The judge lets her finish each sentence before noting it for the record. She pauses, then adds one more line directed toward the bench. Your Honor, I ask you, give him the maximum. Don't give him another chance. He didn't give anyone one. For several seconds after she stops speaking, no one moves. The court reporter's hands rest motionless on the keyboard. The judge leans slightly forward, then speaks quietly. Thank you, ma'am. I am sorry for your loss. Mary nods. She does not add anything further. She returns to her seat at the back of the courtroom. During her walk back, there is no sound other than the faint rustle of clothing. She sits, folding the paper she had prepared but never read from. The judge addresses the room again, reminding everyone that this proceeding is for impact statements only and that decorum must be maintained. But his tone is subdued. The gallery remains silent. The prosecutor looks down. The defense attorney glances toward her client. Jake Haro sits motionless. His head is bowed, hands still clasped. For a long moment, the only audible sound is the quiet sobbing of individuals seated behind the prosecution table. Reporters note tears among several spectators. The court does not adjourn. The judge waits, allowing the emotion in the room to subside before proceeding to the sentencing phase. No additional witnesses speak. The record shows that Mary Ushaz was the sole family member to provide a statement. Her testimony becomes the emotional centerpiece of the hearing. Observers later describe it as a mix of anger, grief, and accusation directed not only at the defendant but at every institution that failed to act. Within the official transcript, each of her major declarations appears verbatim. He destroyed my family. He branded his children for life. CPS gave him too many chances. The record also preserves her direct appeals to the court to impose the harshest sentence allowed and her repeated insistence that systemic neglect enabled the crime. As she spoke, several attendees wept openly. Deputies did not intervene. The judge allowed the moment to continue. The atmosphere of silence following her final words lasted nearly half a minute before the next portion of the hearing resumed. When later summarized in media reports, Mary's address was described as a grandmother's plea for justice and accountability. Court observers noted that even those accustomed to violent crime proceedings appeared moved. The prosecutors themselves were seen wiping their eyes. The transcript reflects no verbal reaction from the defendant. The defense counsel made no objection during the statement. The court proceeded directly afterward to the formal sentencing. The impact of Mary's testimony defined the remainder of the day. It reframed the proceeding from a technical sentencing to a moral reckoning, not only about a single crime, but about repeated institutional failures. When the judge later pronounced the sentence, he explicitly referred to the aggravating factors already documented, though he made no direct reference to Mary's words. Nevertheless, everyone present understood their influence. Her statement crystallized the loss into language that statistics and legal codes could not convey. By the time the gavel struck at the end of the session, those who had listened described the same impression that for a few minutes, the machinery of law had paused to acknowledge human devastation in plain terms. The written record of Mary Ushaw's statement spans several pages. It remains one of the most detailed victim impact addresses ever entered into this case file. Each sentence carries both accusation and testimony, a chronology of warnings unheard and grief unhealed. After the proceeding, the courtroom remained silent long after the judge had left the bench. Deputies waited before opening the doors. The audience filed out quietly, some holding tissues, others covering their faces. Reporters noted that the defendant's wife, Rebecca, was visibly shaken and crying during and after the speech. The defense did not dispute that observation. The court record does not describe any outburst or disruption, only prolonged silence. In the official summary attached to the transcript, the clerk added one line that encapsulated the moment. Following the grandmother's statement, the courtroom remained silent except for audible sobs from multiple attendees. That single sentence, neutral in tone, conveys what the cameras could not. That grief filled every remaining space, leaving even professionals accustomed to tragedy without words. When silence broke. The silence that followed Mary's statement lasted longer than anyone expected. When the judge finally lifted his head, his expression remained composed but his voice carried a gravity that filled the room. He thanked the grandmother again, then turned to the clerk. "We will now proceed with sentencing." Those words marked the end of stillness. The silence broke. The court reporter began typing again, capturing each syllable as the legal process resumed. The deputies returned to their positions near the defendant. Every person in the gallery straightened. The transition from grief to immediate, yet it did not feel clean. The emotional weight of Mary's words lingered between the lines of procedure. The judge reviewed the documents in front of him, the plea agreement, the sentencing memorandum, and the probation report. His reading was quiet but deliberate. When he spoke again, his tone was neutral, the voice of the law reasserting control after an hour of human emotion. The court, having taken the defendant's plea and having reviewed the record, now pronounces sentence. He paused and looked to both counsel tables. "Are both sides ready?" "Mr. Smith nodded. "The people are ready, Your Honor." Defense counsel followed. "Yes, Your Honor." Rebecca raised her head for the first time since the hearing began. Her eyes met Jake's profile, not his eyes, only the side of his face. He didn't look at her. He didn't move. Her lips parted, but no sound came. The tissue in her hand was now just shreds of paper. Observers noted her visible distress. The record shows no disruption, only quiet sobbing. Her attorney placed a hand on her shoulder, whispering something that remained unheard to everyone else. The judge resumed. He listed the restitution fines. $10,000 for restitution. A matching $10,000 for parole revocation. Stayed pending completion of sentence. He noted additional court fees and operational assessments, many of which also stayed under state policy. Victim restitution shall be determined at a later date. The defendant is advised that restitution orders carry the force of civil judgments. The clerk repeated the amounts allowed to confirm. The judge turned slightly toward the defense table. "Mr. Haro, you are advised of your right to appeal within 60 days. The defendant nodded once, barely perceptible. "You are required to provide DNA and fingerprint samples as directed. You are prohibited from possessing firearms, ammunition, or body armor. You are ordered to relinquish any in your possession." The formality continued, each line a ritual of the justice system. The judge spoke, the clerk recorded, and the reporter documented every word. "If you are not a citizen of the United States, you are advised that these convictions may result in deportation, exclusion from re-entry, and denial of naturalization." That statement closed the mandatory advice section. The judge paused and took a measured breath. No sentence can restore what has been lost. The court imposes the maximum allowed by law to reflect the seriousness of the offense. At that, he looked briefly toward the gallery, toward Mary, toward Rebecca, toward the faces that had filled the seats since morning. This court acknowledges the pain expressed by the family. May this judgment bring some measure of closure. Mary nodded slightly but did not speak. Her hands rested on her lap, fingers intertwined. She looked straight ahead, her expression calm but distant. The gavel struck once. The sound echoed against the wood, definitive and final. The silence that had dominated the earlier part of the hearing was gone, replaced by the sound of orderlies moving, the shuffle of papers, the metallic clink of chains as the deputies stepped forward. Jake Haro stood when instructed. The deputies fastened his restraints. He gave no verbal response. The defense attorney asked a procedural question about the handling of his legal paperwork. The judge approved. He may transport his documents to and from court. That short exchange completed the record. The prosecutor and defense exchanged brief acknowledgments. No handshake, no conversation. The formalities of law were done. As the deputies prepared to escort the defendant out, the courtroom's focus shifted. Some in the gallery began to cry softly. Others sat in stunned quiet, watching as the man at the center of the case was led toward the side door. The metallic door opened. Jake stepped through, flanked by two deputies. He did not look back. The door closed with a heavy sound that seemed to absorb the last remnants of the trial. Rebecca lowered her head again. Her shoulders shook. The reporter noted only, audience member crying, no disturbance. Her lawyer helped her stand. They waited until the courtroom began to clear before leaving. Mary remained seated longer than anyone else. When the last row of observers began to exit, she slowly rose. She looked once toward the now empty defense table, then toward the bench where the judge had been. A deputy approached quietly, offering to escort her outside. She declined. She walked alone toward the aisle. The press was waiting outside. Cameras were ready. But Mary did not stop. She passed through the corridor without comment. Later, when asked by reporters for a statement, she said only one sentence. "I just wanted him to hear me." Inside, the clerk finished organizing the case files. The last line typed into the official record read, "Defendant remanded to Department of Corrections to begin sentence." That was how the court documented the end, in plain administrative language. But those who attended remembered more. They remembered the contrast, the grandmother's trembling voice, followed by the mechanical precision of the law, the absence of reaction from the man who caused it, the moment when Rebecca collapsed into her hands. Reporters later described it as a courtroom divided between silence and sobs. One article summarized the day in a single sentence. When the sentence was read, the room broke, not in noise, but in sorrow. The cameras that had been still during the session came alive outside. Footage showed Mary walking away under the afternoon light, clutching a small purse, her head slightly bowed. Behind her, Rebecca exited with her attorney, surrounded by deputies. No one spoke to each other. The prosecution held a brief press update at the courthouse steps. Mr. Smith said, "This is the outcome required by law. We thank the court for its careful attention." He made no further comment on the family's statements. The defense did not address the media. Inside the courthouse, the lights in Department 32 dimmed as staff began closing for the day. The courtroom that had held hours of testimony, argument, and silence was once again just a room, wooden benches, a microphone, and a flag behind an empty bench. Yet the sound of that single gavel strike remained in memory, a symbol of closure that did not feel complete. When the official minutes were entered later that week, the court clerk summarized the entire session in under one-page victim impact statement heard from maternal grandmother. Defendant sentenced to 25 years to life plus determinate terms. Probation denied. Restitution ordered. Defendant remanded. Nothing in those lines reflected the emotion inside that room. Nothing could. For those present, the meaning of when silence broke was not just that the judge had spoken. It was that silence had changed form, from restraint to finality. The grandmother's words had filled the room earlier, the sentence filled it now. Both were irreversible. Rebecca later left the courthouse through a side door, avoiding the reporters gathered at the main exit. She was described as pale, her movements unsteady. Her attorney guided her to a waiting car. No statement was given. Mary did not attend the following administrative hearings. Her part in the process had ended, but her testimony continued to circulate through public commentary and media broadcasts. Viewers repeated her lines. "He destroyed my family. He branded his children for life. CPS gave him too many chances." Those sentences became shorthand for Eblick believed had gone wrong. a family destroyed, a system that failed, and a child who never came home. That night, the courthouse lights went out at 8:47 p.m. The file labeled People vs. Haro was sealed for archival processing. But in communities that had followed the case since the day the kidnapping was first reported, conversations continued online and in living rooms. The question from the beginning remained unanswered. Was Emmanuel ever found? The court never confirmed it. Mary's statement, referencing the burial of another grandson, had been misinterpreted by some as proof that Emmanuel's remains were recovered. The record showed no such finding. The official cause of death remained under investigation, the location undisclosed. That uncertainty became the echo that followed the verdict. Even after the courtroom emptied, it stayed, not as noise, but as a quiet persistence. In the transcripts, the last audible event read before adjournment is the judge's voice. Court is adjourned. No applause, no reaction, no interruption, only that line, followed by silence. And yet, in that silence, something irreversible had happened. For months, the story had been built on denial, deception, and absence. In one afternoon, the truth had finally been spoken aloud, not by the defendant, but by those he had silenced. The system had answered with numbers, with terms and codes, but the family's grief had answered with something else, permanence. When silence broke, it did not bring relief. It brought recognition that justice can be delivered, but never repair what has already been destroyed. The court closed its doors that evening, but for everyone who sat inside, the sound of gavel lingered long after they stepped back into the ordinary world. The sentence to life. When the courtroom reconvened for the final reading of the sentence, the tone had shifted from tension to inevitability. The legal groundwork had already been laid. Every argument, every memorandum, and every statement was now behind them. The only words that remained were the judge's. He looked down at the file labeled People v. Haro, the pages already filled with testimony and reports. His voice, when he began, was clear but without inflection, the sound of the judicial record being completed. This court, having taken the defendant's plea and considered the evidence, now pronounced the sentence. The clerk adjusted the microphone. The deputies stepped closer to the defense table. The reporter's keys began their rhythmic tapping again, marking each syllable for the permanent record. The judge's first ruling addressed the most serious count. His tone remained steady, formal. The crime is resulting in death. The only term provided by law is 25 years to life in state prison. He paused long enough for the court reporter to catch up, then continued. This term is imposed as the indeterminate base. Probation is denied. The reason for that denial had already been written in the probation report, but the judge chose to restate it aloud so that there would be no ambiguity. The defendant was on probation for a felony offense at the time of this crime. He was under court supervision toward a child. While under that supervision, he committed the present offense. For that reason, this court finds no grounds for leniency. The language was clinical, but every listener understood what it meant. The system had given Jake Haro second chances before, and each had ended in tragedy. The judge was now closing that door permanently. He moved to the next items on the docket, the lesser but still consequential charges. His reading followed the same deliberate pace, each line separated by an audible pause. In case number BF 22065-2, the upper term of 6 years is imposed. In case number BF 240717, for possession of a firearm by a convicted felon, a consecutive term of 8 months is imposed, representing 1/3 the midterm. For the misdemeanor offense of filing a false police report, a term of 180 days is imposed. All determinate terms shall run consecutive to the indeterminate term of 25 years to life. He looked toward the defendant. Mr. Haro, do you understand the sentence as read? The answer was a single word. Yes. No further statement followed. The judge continued the financial penalties. The law required restitution and fines even when imprisonment was for life. The court imposes a restitution fine in the amount of $10,000. An equal parole revocation restitution fine is imposed and stays pending successful completion of parole. The defendant is ordered to pay additional court security and facility fees, as provided by statute. Victim restitution to the family of the victim shall be determined and ordered at a later date. He added, without looking up from his notes, these amounts are imposed in recognition of the harm caused and in accordance with the people's request. The court finds the maximum restitution fine appropriate given the number of felonies involved. Defense counsel rose briefly. Your Honor, the defense renews its objection to the restitution fine based on indigency. The defendant has no income, is disabled, and the judge raised a hand gently but firmly. The objection is noted and overruled. The fine stands. There was no further protest. The attorney sat down. For a moment the judge stopped reading and spoke directly, leaving the prepared script behind. This case is tragic beyond measurement. The loss of a child is the most painful circumstance any court encounters. The evidence presented demonstrates repeated violations of trust and responsibility. The record reflects a lack of remorse. The defendant's prior history shows that opportunities for rehabilitation were provided and rejected. He adjusted his robe sleeve and continued, his tone tightening slightly. While the defendant entered a plea at an early stage, this court cannot treat that decision as a sign of contrition. It was a procedural act, not a moral one. Then came the line that would later appear in every media report: no sentence can vindicate the loss of innocence. The law can impose years, but it cannot restore what was taken. The courtroom remained still. Some in the gallery closed their eyes. The statement had the gravity of a conclusion, yet the judge was not finished. He returned to the text of the law, describing parole eligibility and future conditions of confinement. The defendant, he said, would serve his term in state custody and would not be eligible for parole consideration until the minimum 25-year threshold had been met. Even then, the parole board would be required to consider aggravating factors and the family statements before any decision. Let it be clear, he said, that should any change in statutory law grant this court new discretion to reduce the sentence, the court would decline to do so. The judgment rendered today is final, just, and proportionate. He looked again at the defendant. You are ordered to provide DNA, thumbprint, and palm print samples. You are prohibited from owning or possessing firearms or ammunition. You are advised of your right to appeal within 60 days. Do you understand? Jake nodded again. His voice was barely audible. Yes. He did not look at the judge, the attorneys, or the gallery. His eyes remained fixed on the table in front of him. The chain around his wrists made a small metallic sound as he shifted slightly in his chair. The judge's tone softened but did not change in content. The court hopes that at some point the defendant will reflect on the magnitude of his actions. The sentence imposed is not intended for vengeance but for accountability. He turned to the clerk. Let the record reflect the total term, Sog. 25 years to life, plus 6 years and 8 months, plus 180 days, and a restitution fine of $10,000. The clerk repeated the figures aloud. The reporter typed them into the record. The precision of numbers was the court's final language then. Formally, the defendant is remanded forthwith to the Department of Corrections to begin serving his sentence. The gavel fell once, a single, deliberate strike. The deputies stepped forward immediately. They instructed the defendant to stand. He complied without resistance. His attorney gathered her papers. The prosecutors remained seated, watching silently. Jake Haro did not turn toward the gallery. He did not speak. He did not apologize. His expression did not change. The deputies placed restraints on his wrists and escorted him toward the side door, leading to the holding area. The sound of the door closing marked the physical end of the case. Rebecca was not in the courtroom. The official transcript lists her as absent. Her counsel had notified the clerk earlier that she was unable to attend for personal reasons. For that reason, there was no immediate family reaction to the sentencing from within the defense section. The absence was noted without comment by the court. Mary, the grandmother who had spoken earlier, was present. She remained seated as the courtroom began to clear. The judge looked once in her direction and gave a brief nod, not as ceremony, but as acknowledgement. She did not rise until the deputies had left with the defendant. The reporters who had been present wrote later that the moment felt both final and incomplete. Final because the law had spoken, incomplete because nothing in the law could address the loss itself. After the session ended, the clerk the final entries allowed for verification. Defendant sentenced to 25 years to life for Jake's charge. Additional determinate terms of 6 years and 8 months plus 180 days. Restitution fine of $10,000 imposed. Probation denied. Defendant remanded. These lines were typed into the official minute order before the file was sealed. Outside the courthouse, the prosecution made a brief statement to local media. Mr. Robinson said the sentence reflects the seriousness of the crime and the persistent risk posed by the defendant. He thanked the grandmother for her courage in addressing the court. He declined further comment. The defense issued no statement. The public defender's office later confirmed that no appeal had been filed as of the deadline. For the family, the legal conclusion provided no closure. Community members who had followed the case online and through television coverage expressed mixed emotions. Many described the sentence as appropriate but insufficient. Others said no length of imprisonment could measure the harm. In social commentary and press summaries, one phrase repeated most often: "Justice has been delivered, but the pain has not ended." That sentiment captured the contradiction visible in the courtroom, the mechanical certainty of the law beside the unresolvable grief of those who remained. The judge's remark, "No sentence can vindicate the loss of innocence," became the headline quote. It was reprinted in major outlets and broadcast in evening news segments. Legal analysts noted that it reflected a rare moment of empathy within a procedural judgment. But even that sentence could not soften the reality that the hearing had exposed. In the weeks following the sentencing, the Department of Corrections processed Jake Haro's transfer from county to state custody. His case number F25-48081 was marked active incarceration. He would begin serving the indeterminate term immediately. Meanwhile, the court clerk filed copies of the grandmother's statement and the sentencing transcript with the Victim Services Division, ensuring they would be available at any future parole review 25 years from the date of sentencing. For Mary, those documents represented the only official record of her family's voice. For the public, the sentence represented accountability but not redemption. The system had done what it could, but it could not undo what had already been lost. Within the legal file, the conclusion of the judgment occupies less than 2 pages, yet those 2 pages encapsulate months of investigation, testimony, and heartbreak. The words are simple: judgment pronounced. Defendant remanded to custody. The court adjourned. In that simplicity lies the limit of law, the capacity to record events, to impose numbers, but never to repair the human damage beneath them. The lights in the courtroom dimmed soon after adjournment. Staff collected exhibits and returned them to evidence storage. The chairs were rearranged. By late afternoon, the room was empty again. Only the faint echo of the gavel remained, a reminder of the line that ended the case. For those who had listened to every word, the judge's calm tone, the grandmother's plea, the lawyer's arguments, the sound of that gavel was not only final but haunting. It symbolized closure for the file, not for the people. The legal record concludes with a paragraph entered by the presiding judge himself, typed into the official notes before signing. The court has considered all aggravating and mitigating factors. The sentence imposed is proportionate and justified. While justice may be served within these walls, healing remains beyond the court's reach. That final line, understated and factual, mirrored the sentiment carried out of the courthouse by everyone who had been there. Justice had been delivered. But the pain, the unanswered questions, the fractured family, the memory of a child lost continued long after the courtroom doors closed. Was Emmanuel found? When the court adjourned and the transcript of Mary Ushaw's testimony became public, one sentence spread beyond every other part of her statement. "We buried my grandson on August 5. It appeared only once in the official record, surrounded by lines of grief and chronology, yet within hours it was quoted across social media as proof of something the court had never confirmed, that the missing infant, Emmanuel Haro, had been found. Inside the courtroom, the meaning of Mary's words was clear in context. She had been describing a month of personal tragedy, a stroke, the death of another grandchild, the loss of a sister, and the chaos that followed. The phrase referred to a different child, a grandson who had died earlier in August. But once the transcript circulated online, the context vanished. Readers saw only the fragment. Within a few hours of publication, screenshots of that single line began appearing on discussion boards and community pages devoted to the case. Captions read, "Grandmother says they buried Emmanuel," and "Breaking, the baby has been found." Each post multiplied, each retelling lost another layer of nuance. By the next morning, the question had overtaken every other detail from the hearing. Was the child truly located? Had investigators quietly recovered the remains without announcing it? Or had the grandmother revealed something the court was trying to withhold? The confusion thrived because no authority corrected it. The Riverside County District Attorney's Office issued a short press summary after the sentencing. It listed the counts, the sentence, and a one-line acknowledgement of the victim impact statement. It did not reference the burial remark or the child's status. The Sheriff's Department spokesperson, contacted by multiple outlets, replied only, "We have no new information to release regarding recovery efforts." The FBI field office declined to comment. That official silence, standard procedure in an active recovery investigation, was interpreted online as confirmation by omission. To understand how the misunderstanding spread, analysts later divided it into 3 plausible readings, each drawn from fragments of fact. The literal misreading: Mary was speaking about another grandson who died earlier that month. Her statement in full: "We buried my grandson on the 5th of August. Then on the 14th he called me to say Emmanuel was kidnapped. Then my sister died on the 17th. Read together, the timeline shows 3 separate events: 1 death, 1 disappearance, 1 additional death." Court observers present that day confirmed this interpretation immediately. The judge's clerk later verified that there was no testimony or evidence presented that Emmanuel Haro's remains were recovered. Yet to the digital public, separated from the full transcript, the first clause alone carried a different implication. The emotional gravity of a grandmother describing burial blurred the distinction between one grandchild and another. A second school of speculation insisted that Emmanuel had been found, but that law enforcement and prosecutors were withholding the information pending additional forensic work. Supporters of this theory pointed to the judge's phrasing at sentencing, "No sentence can vindicate the loss of innocence," and claimed it implied the case had reached full resolution. They also noted that no active, missing child bulletin was visible on local agency websites after the sentencing date. In their view, the quiet removal of those listings constituted silent confirmation. Fact-checking by local journalists disproved that assumption. The removal was part of a standard database update. Archived bulletins are automatically hidden once a defendant in the related criminal case is sentenced. It did not indicate recovery. Nevertheless, the pattern fit neatly into an online narrative already hungry for closure. A third, less sensational reading came from grief counselors and linguists who analyzed the transcript linguistically rather than legally. They observed that in moments of extreme trauma, speakers often conflate time and identity. "We buried my grandson" may refer symbolically to the loss of one child while emotionally encompassing another still missing. To Mary Ushaus, the absence of Emmanuel may have felt indistinguishable from death. Her statement, therefore, expressed emotional reality, not factual confirmation. This explanation matched patterns seen in other victim statements, where family members speak of missing loved ones in the past tense as an unconscious acknowledgement of loss. Within 24 hours of the transcript's release, hashtags referencing Emmanuel found trended across multiple platforms. Video channels reposted clips from the hearing, freezing frames on Mary's tearful face as proof. Some content creators overlaid captions like, "Grandmother confirms burial," or "Court covers up discovery." Each repost stripped away more of the surrounding narrative. What had been a single paragraph in a 20-page transcript became a self-contained rumor. By the end of the week, tens of thousands of comments demanded official acknowledgement. Local reporters tried to clarify the record. The Riverside Press Enterprise ran a short correction. The grandmother's statement referred to another grandchild who died earlier in August. There has been no confirmation that Emmanuel Haro's remains were recovered. But corrections never travel as far as rumors. The headline, "Grandmother says they buried Emmanuel," continued circulating in screenshots long after the clarification disappeared from timelines. When questioned by journalists, investigators reiterated that the search for Emmanuel remained open. Evidence collection, they said, was still under review by forensic specialists. No identification had been made. The strict non-disclosure policy governing investigators from confirming or denying any recovery until the coroner issued a definitive report. The coroner, in turn, was bound by statutory confidentiality until next of kin received notification. Those layers of procedure, necessary to protect privacy, created an information vacuum that rumor quickly filled. A senior investigator, speaking anonymously months later, summarized the dilemmas. "If we deny it, people think we're hiding something. If we confirm it, we jeopardize the integrity of the case. Either way, someone accuses us of lying." Major outlets picked up the confusion, some cautiously, others recklessly. Television segments opened with the phrase, "Questions remain tonight," after a grandmother's emotional statement. Anchors repeated the contested quote while superimposing archival footage of the courtroom. Even when reporters added that there was no official confirmation, the framing implied discovery. By the second week, online analytics showed a spike of nearly 600% in searches for Emmanuel Haro found. Forums splintered into competing theories. It was another child. It was Emmanuel. Authorities are hiding the truth. Each group cited the same line as evidence, interpreted through its own lens. For Mary Ushaws, who had never intended to create such speculation, the aftermath was unbearable. Family friends later said she avoided interviews entirely. She declined all follow-up requests. Her earlier statement, "Grandma doesn't know nothing," took on new meaning. She was once again being accused of secrecy in a case she could no longer control. Grief distorts language. Psychologists who specialize in trauma communication note that bereaved relatives often speak in compressed timelines. Events separated by days become fused in memory, pronouns shift. One child's name stands for another. In that state, "we buried my grandson," can signify both a literal event and a metaphor for an emotional burial, the acknowledgement that hope has died. Court transcripts, stripped of tone and pacing, preserve only words. They do not record the pauses, tears, or gestures that give those words meaning. In the typed version, Mary's 3 sentences appear continuous, without the sobs or breaks that witnesses remembered. The flattening of emotion into text allowed a complex moment to be reread as revelation. Law enforcement agencies rarely correct viral misinterpretations because doing so would require commenting on evidence. Prosecutors are bound by ethical rules that forbid public discussion of ongoing matters. Even the judge could not issue clarification once the case was concluded. The result was a vacuum of authority. Into that vacuum stepped commentators, bloggers, and self-styled investigators. Some acted responsibly, quoting official statements, others turned speculation into content. The absence of confirmed information became a canvas for collective imagination. Each new post began with a question and ended with a conclusion. Why would a grandmother say, "We buried him," unless she meant it? The comment spread like a citation, accumulating emotional weight through repetition. Analysts later reconstructed the chronology to anchor the facts. August 5 family funeral for another grandson, unrelated to Emmanuel's disappearance. August 4 the defendant's call reporting Emmanuel as kidnapped. August 17 death of Mary's sister. October 12 Jake Haro sentenced. Following day transcript released, within 48 hours. Misinterpretation viral. The sequence shows how compression of multiple losses into one paragraph produced misunderstanding. The proximity of the dates, all within 12 days, made it easy for readers to merge them into a single tragedy. The digital public split into camps. Some demanded the immediate release of the burial site. Others accused media outlets of exploiting grief. A smaller number appealed for restraint, posting screenshots of the full transcript and underlining the words. Then on the 14th he called me to say Emmanuel was kidnapped. Yet the corrective posts reached only fractions of the audience drawn to sensational claims. Within a week, videos labeled "Emmanuel found," "Proof from courtroom," amassed hundreds of thousands of views. Comment sections filled with condolences written as if death had been confirmed. In local vigils, participants brought candles not only for justice but for remembrance. Even uncertainty became grief. People needed closure, and the grandmother's sentence supplied it, however inaccurately. The episode illustrated the fragility of information in high-emotion cases. A single unverified interpretation can outpace official statements by orders of magnitude. Once internalized by the public, even clear corrections struggle to dislodge belief. Legal ethicists reviewing the Haro transcript later recommended that courts provide brief context notes when releasing victim impact statements, explaining that personal remarks may include unrelated family losses. The suggestion underscored how transparency sometimes requires narrative framing, not secrecy. Months after sentencing, official channels still listed Emmanuel Haro as missing, presumed deceased. The investigation file remained active but sealed. No public document confirmed recovery. Inquiries to the county coroner produced the same response. No record under that name. Despite that, online memory had already rewritten the story. In many community archives, Emmanuel appeared under the category, "Found Victims." The truth and the rumor existed side by side, indistinguishable to casual readers. The misunderstanding surrounding Mary's sentence is more than a footnote. It demonstrates how grief bureaucracy and digital speed can intersect to reshape reality. In an earlier era, such a misreading might have remained a localized rumor. In the current media environment, it became an alternate version of events, repeated often enough to challenge the official one. For investigators, the rumor complicated their work. Tips dried up, witnesses assumed the case was solved. Potential evidence went unreported because the public believed there was no longer a search. In that sense, misinformation did not merely distort perception, it potentially hindered justice. Mary never clarified the remark publicly. Friends said she refused further interviews, explaining only that, "Everything I said was true to my heart." Those who knew her understood she had already lived through multiple funerals in 1 month. The distinction between which grandchild was buried may have felt secondary to the reality that all of them, in one way or another, were gone from her life. Her silence became its own statement. To some, it confirmed guilt, to others, it confirmed exhaustion. In truth, it confirmed only grief. Months later, when online discussions resurfaced after anniversaries or memorial posts, the same question reopened each time: was Emmanuel found? The answer, as of every official update, remained the same: no confirmed recovery, no public report, investigation ongoing. But factual answers rarely satisfy emotional questions. The community's need for resolution outpaced the evidence available. In that imbalance lay the lasting tension of the case. Criminologists later compared the Haro confusion with similar cases where language from family statements created unintended narratives. Each followed the same structure: a phrase of grief uttered under stress, selective amplification by media, institutional silence constrained by law, public reinterpretation as revelation, permanent coexistence of truth and rumor. The Haro transcript became a teaching example in seminars on media ethics and trauma communication. It showed how precision in law does not equate to clarity in perception. As time passed, what remained in collective memory was not the sentencing length or the legal language but the grandmother's single sentence. Her voice, trembling, fragmented, human, outlived the court's measured tone. The paradox was painful. In trying to honor her loss, the public transformed her words into a new source of confusion. Her truth was emotional, the public's interpretation was literal. Between them lay a silence neither side could cross. The file labeled People v. Haro now sits in the archives of the Riverside County Superior Court. The pages are precise charges, plea sentence, and the victim impact statement. Nowhere does it declare Emmanuel found or buried. Yet outside the building, the debate continues in comment threads and whispered conversations. The narrator's voice, stepping back from the evidence, summarizes what remains. We search for closure the way investigators search for bodies, methodically, sometimes hopelessly. In this case, the search continues in both forms. The record closes with a sentence of life imprisonment, but another question stays open. Was Emmanuel found? The answer lives in silence. Some truths die with it, and some are buried, not in soil, but in grief. The unfinished story. When the gavel fell, the story did not end. It simply left the courtroom and began living elsewhere, in headlines, in timelines, and in the collective memory of everyone who had followed the case from its first desperate search to the day of judgment. Within hours of sentencing, clips from the hearing spread online. The most shared moments were not the judge's words, nor the reading of the sentence, but the human reactions: Mary's trembling testimony, Rebecca's collapse, and the deputies leading Jake away in silence. Each clip carried the same caption: Justice for Emmanuel. The comment sections filled faster than news outlets could post updates. The tone was raw, emotional, and divided between outrage and sorrow. Who kills a baby? CPS has failed again. He's dangerous to children. Hundreds of similar remarks echoed across platforms. Each voice, though typed from a distance, carried the same belief that such an outcome could have been prevented if warnings had been heard earlier. Some users blamed the system, others blamed the silence of those who might have known. A few simply wrote prayers or emojis, hearts broken in red and black. Within a day, hashtags like Justice for Emmanuel and CPS failed again appeared on every major social platform. Viewers reposted fragments of the video: the moment when Mary demanded Jake look at her, the second when Rebecca lost her balance as the sentence was read, and the close-up of the judge stating, "No sentence can vindicate the loss of innocence." Those seconds became symbols. They carried the emotion that legal language could not express. To millions watching from screens, the hearing was no longer just a case. It was a manifestation of collective grief. Sociologists studying the reaction later described it as a modern ritual of mourning. The courtroom had served as the stage, but the audience extended far beyond its walls. Viewers who had never met the family spoke as though they had. They felt entitled to grieve, to accuse, to demand reform. The crime had become communal. Digital empathy transformed into digital outrage. Some called for new laws limiting parental custody for offenders already under probation. Others directed anger at the county's child protective services, repeating Mary's words. They gave him too many chances. Screenshots of her statement were overlaid on black backgrounds, shared thousands of times. The irony was that the same system she blamed now faced another wave of public scrutiny. Employees received threats. Offices were flooded with messages. The internet's grief had found a target. Among all the circulated footage, one clip became iconic: Jake standing motionless as the judge read his sentence. In the background, Mary's voice still echoed faintly, captured by courtroom microphones. Just seconds after the judge said, 25 years to life, Rebecca's head fell forward, She was caught by her attorney before she hit the table. That collapse, brief, unscripted, and wordless, was replayed endlessly online. Some viewers saw it as guilt, others as grief. Psychologists invited on talk shows interpreted it as the physical manifestation of emotional implosion. For those who had followed the case from the beginning, it symbolized the unbearable intersection of justice and loss. Every upload carried thousands of comments. She couldn't hold it anymore. That's when she realized it's over. Where's Emmanuel? Even now, months after the sentencing, the clip continues to circulate whenever discussions of justice system failure reappear. It became, unintentionally, the defining image of the entire trial. Mainstream outlets reported the facts, but social media reshaped the emotion. Headlines read, Jake Haro sentenced to 25 years to life. Grandmother confronts defendant. Ha destroyed my family. Mother faints during sentencing. The brevity of those titles made the story accessible, but it also simplified its complexity. The public consumed the event as tragedy compressed into sound bites. Even television anchors spoke with visible strain. Evening newscasts replayed Mary's voice, her accent trembling as she demanded accountability. Who gave him another chance? Reporters added captions. A grandmother's plea echoes nationwide. The visual impact of that plea, her standing in the witness box, refusing to sit, insisting the defendant face her, resonated far beyond the courtroom. Viewers recognized in her something universal, the image of someone who had lost everything yet still demanded truth. While Jake's sentencing concluded the criminal case against him, the story was far from over. Rebecca Haro, facing separate charges for false reporting and possible complicity, awaited her own trial. The prosecution maintained that her case would proceed independently. The judge's docket listed a tentative date for February of the following year. Public reaction to her absence from the sentencing was intense. Some interpreted it as avoidance, others as collapse. Her attorney released a short statement, Ms. Haro is emotionally and physically unwell following the verdict. She continues to cooperate with authorities. The internet was less forgiving. Comment sections filled with declarations. She knows more than she says. She needs to tell the truth. Justice for Emmanuel is not complete until she speaks. The community's collective focus shifted from the convicted father to the silent mother, demanding answers she might never be able to give. The unfinished aspect of her trial mirrored the unresolved question that haunted everyone: was Emmanuel ever found? After the sentencing, Mary walked out of the courthouse through the side entrance. Reporters shouted questions. Do you feel justice was served? She did not answer. Witnesses described her as calm but vacant, her gaze fixed ahead. Her walk was slow, deliberate, almost detached. She carried no papers, no bag, only the expression of someone emptied by grief. A journalist who followed her to the parking lot noted in his report, she did not cry, she did not speak. She just kept walking, as if leaving something behind that could no longer follow her. The silence of that moment contrasted sharply with the noise online. Inside the courthouse, justice had been formal and structured. Outside, emotion was chaotic and uncontrolled. Mary's distance became its own statement, the final refusal to engage with the spectacle surrounding her family's loss. As videos spread, two opposing narratives took shape. One saw the sentencing as a triumph of justice, proof that the system could still hold offenders accountable. The other viewed it as another example of failure, too little, too late, with one parent free and a child still missing. In both camps, emotion outweighed fact. Threads discussing forensic reports and legal details quickly devolved into arguments about morality and punishment. He should never see daylight again, wrote one viewer. He deserves worse than prison, wrote another. The tone was absolute, unforgiving. Even those unfamiliar with the case's full background adopted positions as if personally involved. The courtroom had transformed from a physical place into a symbolic battlefield between grief and justice, between what had been proven and what could never be known. Observers noted that public reaction to the Haro sentencing reflected a deeper societal unease. It wasn't just about one family or one crime. It was about every headline that began with a child's disappearance and ended with bureaucratic failure. Each case reopened collective wounds, reminders of those who had vanished without explanation, of systems that acted too late, of protection promised but never delivered. People saw their own stories in Mary's words. Parents reposted the video with captions like, "This could have been my child." Advocacy groups used it to campaign for stronger oversight of child welfare departments. Even politicians referenced it in speeches about reform. The trial had transcended its particulars, it had become allegory. Documentary producers requested permission to use courtroom footage in future episodes about system failures. Advocacy podcasts discussed the grandmother's speech as masterclass in unfiltered truth. University law classes analyzed the sentencing transcript as a study in judicial restraint amid emotional chaos. Meanwhile, in online memorial spaces, Emmanuel's photo, one of the few released to the public, appeared alongside messages of apology and mourning. Some users left digital candles, others simply wrote his name followed by a heart. In every version of the story, one line endured. Justice begins not with answers, but with the refusal to forget. That sentence, spoken in the documentary voice-over released shortly after the verdict, resonated as both a closure and a challenge. It reminded viewers that justice, in this case, was procedural, not restorative. The system had done what it could. The rest depended on memory. As weeks turned into months, the narrative fragmented further. Some remembered the sentencing, others remembered the rumor that Emmanuel had been found. Both stories coexisted, often in the same threads, creating a tapestry of half-truths and unresolved grief. The distinction between justice and closure blurred. For many, justice felt incomplete without recovery. For others, the sentence was the only closure possible. The digital public, unable to accept ambiguity, sought definitive endings in a case that refused to provide one. Commenters returned to the same question. If he's in prison, where is Emmanuel? No one could answer. Each repetition deepened the wound rather than healed it. Rebecca's case moved slowly. Hearings were postponed. Each delay renewed speculation. Journalists revisited court filings, piecing together fragments that revealed little. Prosecutors maintained confidentiality, defense attorneys declined interviews. The absence of news became its own kind of headline. Mary remained out of the public eye. Neighbors described her as quiet, distant, polite. Those who visited her said she avoided discussing the trial. She tended her small garden and cared for surviving grandchildren, but refused all requests for comment. Silence, once forced upon her by tragedy, had become her chosen defense. As the case faded from daily news cycles, its emotional residue persisted. True crime communities referenced it whenever discussing failures of child protection. The image of the grandmother confronting the defendant resurfaced in compilations of most powerful courtroom moments. Each replay renewed the emotional charge, as if the trial were happening again. Public grief became institutional memory, absorbed into ongoing debates about oversight, sentencing, and reform. But beyond policy, the story endured because it captured something made the unbearable endurance of love in the face of loss. The closing scene of the documentary version mirrored the end of the courtroom day. The screen faded from the image of Mary walking through the courthouse doors to a black background. Her final words echoed faintly. He didn't give them a chance. Then the narrator's voice returned, calm and reflective. Justice begins not with answers, but with the refusal to forget. It was not a gimmick but a mirror, a way of asking the audience whether they still believed in resolution. The poll results, collected over the next week, revealed a divided conscience. Nearly half chose not yet. It reflected something larger than uncertainty. It reflected hope against evidence, belief against silence. In narrative terms, the Haro case reached its legal conclusion. But emotionally, it remained unfinished because one essential element, the whereabouts of the child, remained unknown. Without that, the sentence was an equation missing its final variable. The math of justice worked, the math of grief did not. Unfinished stories linger longer than resolved ones. They replay in the mind, asking what might have been done differently. They force societies to look at their own structures and admit fragility. The Haro story, in that sense, outlived its immediate participants. It became an emblem of systemic failure and personal devastation intertwined. Every year, candlelight vigils continue in parts of Riverside County. Community members gather with printed photos of missing children, Emmanuel's among them. The phrase, "refuse to forget," has become the event's unofficial theme. It's painted on banners, written in chalk outside schools, and whispered in prayers. The image of Mary walking silently from the courthouse often opens these memorials. She never attends, but her presence is felt. Her testimony remains quoted as both accusation and warning. The legal system has closed the file, but the moral file remains open, indefinitely. In the end, the aftermath and The unfinished story is not about the crime alone, but about what follows when justice meets the limits of knowledge. The internet remembers what the record omits, the community grieves what the system cannot restore. Jake serves his sentence. Rebecca waits for her own. Mary continues in silence. The public continues to ask. And somewhere between them all, the absence of Emmanuel remains, invisible but central, defining every reaction and every unanswered question. The narrator's final words return one last time, closing the screen in white text against black. Justice begins not with answers, but with the refusal to forget.